This is Judge Mackenzie Smith. She's a judge in Chester County, so you guys are in good hands. Good luck, everyone.
Thank you. Thank you.
You can be seated. I have no paperwork out here.
Yes, Your Honor. We both have notices of appearances.
Perfect.
Would you like us to make our introductions and then hand you them?
Yes, please, go ahead.
Good morning, Your Honor. I'm Omega Adams, and this is Blake Cordova. Today, we have the honor of representing the estate of Clark Doig. We have a few preliminary matters and a motion, but first, would you like our notice of appearance?
Yes, you can approach, thank you.
And then to the jury. Thank you so much. Tell us your team number. Team number 106. Thank you very much. Of course.
Right, and for the defendant.
Good morning, Your Honor. My name is Connor Yost, and I'm joined by my co-counsel.
Good morning, Your Honor. My name is Kristen Ballard.
Good morning.
And together we represent the defendant in this case, the Klein Wrestling Alliance. Your Honor, we also have notices of appearance with the correct spelling of our names, as well as our team designation. May my co-counsel approach for Your Honor with a copy, as well as for the members of the jury.
Yes, please. And team number.
101. And Your Honor, we also have a number of preliminary matters, as well as 3 substantive motions to take up with the court whenever Your Honor is ready.
All right, good morning, everyone. We are here in my civil docket number 20-BOTE-24. Administrator of the estate of Clark Doig versus defendant Klein Wrestling Alliance. Let me hear from the plaintiff as to your preliminary matters and motion.
Yes, Your Honor. First, may we have free leave of the well?
You may.
Second, when approaching the witness, would you like us to ask the first time or every time?
First time sufficient, thank you.
Further, Your Honor, there is a joint exhibit list located on page 2 of the record. Throughout today's trial, may all exhibits just retain their original exhibit number.
Any objection?
No objection, Your Honor.
It's fine.
Also, Your Honor, we had a very successful meet and confer with opposing counsel and stipulated to a few exhibits. May we list those off to Your Honor now?
Yes, please.
First, we have Exhibit 1, which is a photo of Clark Doig, followed by Exhibit 3, which is a photo of the arena at the Klein Wrestling Alliance. Then we have Exhibit 5, which is the catwalk at the Klein Wrestling Alliance. Then Exhibit 6A, which is the physical snap shackle lock, followed by Exhibit 8A, which is the physical locking carabiner. Finally, we have Exhibit 11, which is a diagram of the setup of equipment on August 6, 2022. At this time, plaintiff moves to admit those pieces of evidence into evidence.
All right, any objection from the defendant?
No objection, Your Honor.
Okay, good. Those are 1, 3, 5, 6A, 8A, and 11 are admitted per the party's stipulation.
Further, when publishing exhibits before the jury, would you like us to ask permission or publish freely?
Are you talking about these stipulated exhibits or all exhibits?
All exhibits, Your
Okay,
Honor.
I think for the stipulated ones, it's fine, and then if there's something that I need to hear an objection on and that hasn't been admitted yet, you can ask permission, okay?
Yes, Your Honor. Also, when doing objections, would you like us to constructively move outside the presence of the jury or assume we're outside the presence of the jury?
Any objection to assuming we're outside the presence of the jury, just for ease of movement or lack thereof?
No objection, Your Honor.
Alright, very good, we'll do it that way.
Also, Your Honor, just to put the court on notice, both parties have agreed that exhibits already admitted, may be used during opening statements.
Very good.
Further, would Your Honor like us to formally tender experts in today's case or lay the foundation and move on?
Any objection to, well, lay the foundation and then move on, and if there's an objection, I'll hear it, okay?
Sounds good, Your Honor. Further, we just want to put Your Honor on notice of a few court rulings that I'm sure you're already aware of. The first is court order number 2, which states that this is a trial on liability only and no mention of damages will be used in today's trial. The second is court order number 10, which states that the parties may demonstrate to the jury how exhibits 6A and 8A work by attaching either both or either of the exhibits to anything naturally present in the courtroom, which includes bags, exhibit boxes, and things of the like.
Thank you. I had totally forgotten making those orders, but I appreciate the refresher. All right.
And finally, Your Honor, we move to invoke Rule 615, the constructive sequestration of all witnesses, with the exception of our expert, Mr. Rivers Sukesh.
Any objection?
Your Honor, we would also ask that our expert, as well as our party representative here today, Cody remain in the courtroom.
That is granted on both sides.
With that, we're ready to proceed to motions.
Any other preliminary matters on behalf of the defense that I need to hear before we address pretrial motions?
Yes, Your Honor. Pursuant to the pretrial order in this case, we would like to put the court on notice that Clark Doig's statements have been ruled as party opponent statements to resolve any hearsay issues here today. Clark Doig being the decedent, being represented by the plaintiff here today. And with that, Your Honor, we are ready to proceed to our 3 substantive motions.
All right, I'll hear, how many motions on behalf of the plaintiff am I hearing?
Only one, Your Honor, and my co-counsel, Mr. Cordova, will take care of it.
All right, go ahead whenever you're ready, counsel.
Yes, Your Honor. Plaintiff moves to exclude an opinion from the defense's expert, Ms. Cal Sism, that cannot meet the required prongs of Rule 702. By way of background, the estate of Clark Doig has brought a negligence claim against the defendant KWA for the wrongful death of Mr. Doig when KWA required Mr. Doig to perform a wrestling stunt using improper equipment, which ultimately led him to fall to his death from 78 feet in the air on August 6, 2022. Plaintiffs expect the defense to call Ms. Sism as an expert in this case. Ms. Sism created an expert report and opined on a number of different things. One of these opinions is that the August 6 stunt was much safer than many of the jumps that Clark Doig has performed previously, essentially saying that this was the safest stunt that Mr. Doig performed for KWA. By opining that one stunt is safer than another, Ms. Sism is essentially forming an opinion that this is the safest stunt and as to the safety of all of Mr. Doig's prior stunts. The problem with that is Ms. Sism does not know anything about these prior stunts to satisfy the requirement of sufficient facts and data under Rule 702, and therefore this specific opinion should be excluded.
All right, counsel?
Your Honor, counsel's argument goes to weight and not admissibility of this evidence. Ms. Sism is a stunt safety expert with decades of experience in the wrestling industry. Moreover, she was able to review the entire record in this case, which gave her knowledge of Mr. Doig's prior stunts, including the fact that this was a stunt wherein he was harnessed, and other stunts he had not previously been harnessed. She is able to give this opinion because she does have sufficient facts, data, and expertise.
All right, any rebuttal argument before I roll on the motion?
Yes, Your Honor. Even if Ms. Sism has experience in stunts and experience in performers using a harness, she cannot form this opinion on that basis alone. Ms. Sism does not have sufficient facts based on the depositions and the materials that she reviewed in this case, because there is nothing in these depositions and materials that discuss whether any of the prior stunts used a harness, used rappelling equipment, used release equipment, or even if a stunt coordinator was involved. Ms. Sism does not have the sufficient facts and data to base this opinion by comparing the August 6th stunt to any or all prior jumps that Mr. Doig has performed, and therefore this opinion should be excluded under Rule 702.
Anything further?
Yes, Your Honor, just a point of clarity. There is evidence within this record that Ms. Sism has reviewed that this was the first stunt wherein Mr. Doig was harnessed. So she does have the sufficient facts and information to opine on the safety of a harness stunt versus other non-harnessed jump stunts from different heights.
All right. The court has considered argument of counsel as well as the tenets of Rule 702B and applicable case law, and the motion is denied. The counsel for the defendant may offer this opinion into evidence, subject, of course, to cross-examination. Thank you.
Sure.
Motions on behalf of the defendant.
Yes, Your Honor, we were able to have, as opposing counsel mentioned, a very successful meet and confer. And we've been able to stipulate to 3 substantive motions.
All right.
So for the first motion, the parties have agreed to make no reference or mention to any changes to the KWA's safety policies after this incident, as they are inadmissible subsequent remedial measures.
Okay, does that accurately reflect the stipulation that's been entered?
Yes, Your Honor.
All right, that will be granted.
For the second motion, the parties have agreed to make no reference or mention to a prior 2019 lawsuit wherein KWA was sued by a previous wrestler for negligence.
Same question, does that accurately reflect the agreement of counsel?
That's our understanding, Your
All
Honor.
right, that will also be granted. Finally,
And for our third and final motion, Your Honor, the parties have agreed to make no reference or mention of any statements made by the defendant owner, in this case, Cody Cotter, that the show must go on, or any mention of the fact that the wrestling match, the Brotherly Slam, on August 6th, continued after Mr. Doig was taken to the hospital via ambulance.
all right. Does that accurately reflect the agreement of counsel as to this final motion?
It does, Your Honor.
All right, very good. Those three motions will be granted. Anything further by way of preliminary matters that requires the court's attention before we begin opening statements?
Nothing further, Your Honor. The defense is ready to proceed with trial.
We're also ready to proceed to opening statements, Your Honor.
All right, very good. Ladies and gentlemen of the jury, you will now hear opening statements of counsel. You should not consider these statements as evidence, but only as a preview of what you will hear and what the parties expect to be able to prove throughout the continuation of this trial. All right, counsel for the estate, you may proceed with opening whenever you're ready.
Yes, Your Honor. Crowd gathers in the Philadelphia wrestling arena for one of the most anticipated wrestling acts of the night, the Dragon. That night, the Dragon was going to be performing a new stunt designed by the company's owner, designed with the hopes of continuing to generate excitement for this new character. The wrestler would be lowered down from the catwalk, located 78 feet in the air. As the wrestler was lowered down and got closer to the mat, just 5 feet above, he would release himself and make it seem like he'd clumsily fallen down. As the company's owner lowered that wrestler, something went. That wrestler started falling too soon and too fast, and he hit the mat hard. That wrestler did not get it. That wrestler was Clark Doig. At the time of his death, he was 35 years old and had been wrestling for most of his adult life. But Clark was more than just a wrestler. Clark was a husband. Clark was a father. Clark was a friend. On August 6th, 2022, Clark Doig died. Died while performing a stunt designed by this defendant. A stunt this defendant designed that they knew they were not qualified to. A stunt this defendant designed without consulting a stunt coordinator. A stunt this defendant designed with a piece of equipment that they found on Amazon. Equipment that cost $15.99. Safety is never expensive. It's priceless. Clark was an excellent wrestler, and he spent most of his career working for independent wrestling companies called indies. That's how he came to work for the defendant Klein Wrestling Alliance, a Philadelphia indie wrestling company. Klein Wrestling Alliance is owned by Cody Cotter, and Clark went to work for them in 2019 and then returned in 2021 when the matches started up again after the pandemic. You see, while Clark was always a good technical wrestler, he had trouble connecting with the fans and did not draw in the big crowds. But you see, the problem was never with his wrestling. It was his character, or gimmick, as they call it in the wrestling world. By the summer of 2022, the defendant had given Clark an ultimatum. Either draw more crowd interest, or your time with KWA will come to an end. So the defendant comes up with a new idea for a new gimmick. They designed the dragon. A high-flying, lovable idiot in a dragon costume. Clark didn't have a choice. Do this gimmick and everything that goes along with it, or you will be out of luck with KWA. So Clark agrees. He puts on the costume and becomes the dragon. Surprisingly, it works. Fans started to connect with the dragon. That wasn't enough for the defendant. You see, the defendant saw the interest of the crowds as an opportunity. But they needed to up the ante. And what better time to do it than with KWA's biggest moneymaker coming, the Brotherly Slam. At the time, KWA needed money. They needed to sell more tickets. They needed to sell more merchandise. They needed something exciting. A show, a stunt, a high-flying aerial stunt. They needed the dragon. So this defendant makes the decision to use a stunt. A stunt that he had used before that was designed for him by a stunt coordinator back in 2021. A stunt using two locking carabiners, As the company's owner watches during the practice, it's just not what he had envisioned. It was taking Clark too long to maneuver his body and manipulate this locking carabiner. It just didn't have the effect that the defendant wanted. So what does the defendant do? Does he reach out to that stunt coordinator from 2021 and ask if there's a safe solution? Does he reach out to another expert in this field to see if there's a safe and effective way to pull off the stunt that he sees in his head? No. The defendant decides to solve this problem on his own. The owner of KWA, Cody Cotter, gets onto his computer, logs into his Amazon account. This is what he finds. It's called a snap shackle. It's used for sailboats, not stunt safety. But this wasn't the only decision that the defendant made in terms of safety equipment. You will learn that the defendant found this snap shackle on Amazon, and it came in a 2-pack. But the defendant chose to only use one snap shackle. You will learn that had the defendant used both snap shackles and one of them released early, the second snap shackle would have prevented Clark from falling. You will also learn that the reason the defendant did not reach out to that stunt coordinator from 2021 or any stunt coordinator for that matter is because it was going to cost him $2,000. Safety is never expensive. It's priceless. Members of the jury, we brought this case today because the defendant was negligent. When they designed a wrestling stunt, they knew they were not qualified to design. A wrestling stunt, they designed with inadequate safety equipment and personnel. A wrestling stunt, they designed in a way that was destined to fail. Because we brought this case today, we have the burden of proving by a preponderance of the evidence, just more likely than not true, that the defendant's failures led to the death of Clark Doig. Members of the jury, we will meet our burden today. In order to meet our burden, we retain the services of an expert in stunt safety, Mr. Sukesh. Mr. Sukesh has been a stunt coordinator for several years. He's certified in work at height safety and has been in this field for almost 23 years. He's going to tell you today that the device, that snap shackle, was not designed for holding people up in the air. It was designed for sailboats. He's also going to tell you that if the defendant had to use that snap shackle, they could have used two, so that the other one would have prevented Clark from falling. And as a stunt coordinator himself, Mr. Sukesh is going to tell you that the defendant should have hired a stunt coordinator for the design and supervision of this stunt. Now, we're also going to call Sid Gaskin to the stand today. Mr. Gaskin is going to tell you that during the practices for the August 6, 2022 stunt, Clark was struggling with the safety vest, that it was uncomfortable, and he was moving around too much, like he was trying to adjust the vest. But you will learn that Sid wasn't the only one who saw this. The owner of KWA saw this too. You will learn at one point, Cody went down to Clark and told him not to move in the vest. But at no point did the owner of KWA tell Clark not to move because the snap shackle would release early. This defendant failed Clark Doig when they failed to provide sufficient safety equipment. When they failed to provide sufficient safety personnel. And when they failed to warn Clark about the risks of the snap shackle releasing early. By the end of this trial, you will know what we know. That had the defendant used the proper equipment, or spent the mere $2,000 on a stunt coordinator, this tragedy could have been avoided. Instead, this defendant designed a stunt with a piece of equipment that cost $15.99. He designed this stunt that led to Clark Doig's death. Safety is never expensive. It's priceless. Find the defendant liable.
Counsel for the Alliance, whenever you're ready.
Yes, Your Honor. Counsel, may I grab the exhibits? Thank you. They ran it together. Members of the jury, we agree. This was a risky stunt, but the evidence will show that it was a reasonably risky stunt to take. And at no point today will we try to tell you that it wasn't a reasonable risk. But when the plaintiff was up here moments ago, they made it seem like KWA was the only one that knew that this stunt was risky. But the evidence will show that Clark Doig, he knew it too. KWA and Mr. Doig were a team. You'll learn today that together they looked at this shackle, and together they talked about pulling this rope to open it, and together they practiced with this shackle and this rope 4 times. And they both knew that this shackle was easier to open. They were in it together. Members of the jury, what happened to Mr. Doig is tragic. But today, the plaintiff has the burden to prove that his death was KWA's fault. And we understand, KWA was a part of this stunt, but they weren't in it alone. And that's why we have raised the affirmative defense of assumption of the risk, which means that we have a burden here today too. We must prove that it's more likely than not that Clark Doig knew about and assumed the risk of this stunt. And we'll meet that burden here today by proving two things. That together, KWA and Mr. Doig planned and practiced. But before we talk about how they planned and practiced, let's take a step back and talk about KWA and entertainment wrestling. KWA is a small professional wrestling company located right here in Philly. And the wrestlers, they take on character roles. Think of it this way. In the WWE, we have The Rock, The Undertaker, and Stone Cold Steve Austin. The same could be said about KWA. These wrestlers take on those characters, step into the ring, and they physically fight each other while the fans cheer them on. It's a violent, aggressive, and even a dangerous business. And we don't deny or dispute any of that. But you'll learn today that Clark Doig, he knew that better than most. He was KWA's oldest, most experienced, high-flying wrestler, which means that he knew how to jump off 12-foot ladders and 16-foot cages and then land precisely so he wouldn't hurt himself or someone else. Now, when the plaintiff was up here moments ago, they said that KWA gave Mr. Doig an ultimatum, that they forced and pressured him into this stunt. But you'll learn today that the evidence does not support that claim. You'll learn that KWA and Mr. Doig were a team, and they had worked together for years trying to create a successful character for Mr. Doig. In fact, you'll learn here today that Mr. Doig had turned down multiple character ideas from KWA and continued to work with them to find the right fit. And in June of 2022, just a few months before this tragic incident, Mr. Doig, well, he became Clark the Dragon Doig, and the dragon took off. The fans embraced it. And that's what led KWA and Mr. Doig coming up with that plan that I mentioned earlier. A plan to create even more fan excitement around the growing success of the dragon. A plan for the dragon to do an exciting stunt at a big live event where the dragon would descend from the ceiling down to the ring with his arms stretched out to his sides. Then he'd quickly release himself, drop into the ring, and begin fighting his opponent. Now, the initial plan was for Mr. Doig to be attached to this locked carabiner. But you'll learn today that when they first started practicing, Mr. Doig struggled to release himself. And moments ago, the plaintiff said that this wasn't what KWA envisioned. But you'll learn today that it wasn't what Mr. Doig envisioned either. In fact, what the plaintiff didn't mention moments ago, that you'll learn here today, Mr. Doig complained about this carabiner. Mr. Doig said, "It feels so lame, just dangling, trying to unlock this thing." Members of the jury, this brings us to the shackle. And something that the plaintiff didn't mention moments ago is that when the owner first got the shackle, he didn't just slap it on Mr. Doig and say good luck. No. The owner showed Mr. Doig the shackle, told him it would solve the release issue, told him that it was safe, and reminded him not to move his body because it could cause the shackle to release. Together, they agreed to use the shackle. And together, they agreed to trust in Mr. Doig's experience as a precision and technical wrestler. And that's what led KWA and Mr. Doig practicing this plan. That's right, they practiced. They practiced with that shackle. And they practiced with that shackle together 4 times. And pay close attention to what Mr. Doig said after those practice runs. Another thing that the plaintiff didn't tell you. Wow, it's so much easier to open this shackle than the other one. And not only that, but you'll learn here today that Mr. Doig was reminded again not to move his body, especially his arms, because it could cause the shackle to release. Members of the jury, you won't hear any evidence today that Mr. Doig didn't want to do this stunt, or that he didn't agree to do this stunt. And again, the plaintiff mentioned that this was an ultimatum. But you'll learn today that just moments before this stunt occurred, Mr. Doig was asked, "Are you sure you want to do this?" And in response, Mr. Doig laughed and he said, "It's time for the dragon to fly." They were in it together. And that's why, at the end of this trial, my co-counsel, Ms. Fowler, will come before you and ask you to return the only verdict consistent with the facts, the law, and your own common sense. A verdict that, yes, we agree, acknowledges that KWA took a reasonable risk in this stunt, but also a verdict that recognizes that Clark Doig assumed the risk of this stunt because they were in it together. Thank you.
Thank you, counsel. I should have asked this prior, but is someone keeping time?
Yes, Your
All
Honor.
right, perfect. All right, and if you can call your first witness whenever you're ready.
The plaintiff calls Sid Gaskin to the stand.
Be seated. All right, then sworn to counsel, you can begin your direct examination whenever you're ready.
Introduce yourself to us.
My name is Sid Gaskins.
Mr. Gaskins, are you familiar with the Klein Wrestling Alliance?
Yes, ma'am, I am.
What is it?
Klein Wrestling Alliance is a company that hosts different wrestling events and fights.
How are you so familiar with the Klein Wrestling Alliance?
I used to work for KWA. I was a booker and a ring announcer.
Do you still work for the Klein Wrestling Alliance, Mr. Gaskins?
No, ma'am, I was fired in 2023.
Do you know why you were let go from KWA?
Cody said he didn't like my storylines.
Well, since you worked for the Klein Wrestling Alliance, you know what the Brotherly Slam is.
I do. That's an event that we hosted on August 6th of 2023.
Describe to us what the Brotherly Slam is.
It's where we get a lot of our big and important different wrestlers together. There's all kinds of different storylines, all kinds of different gimmicks going on. It's typically one of our biggest nights.
Now, also, since you worked at the Klein Wrestling Alliance, do you know who Clark Doig is?
Yes, ma'am, I do.
What was Clark Doig supposed to do at the Brotherly Slam, Mr. Gaskins?
Clark was going to be trying his new gimmick and a new aerial stunt.
What happened to Mr. Doig that day?
Unfortunately, something went wrong with the stunt and he passed away.
Let's talk a little bit more about Clark. I'm going to show you a picture of Mr. Doig. Cite important counsel to what's already in evidence as Exhibit 1 and publishing with the jury this summer. Mr. Gaskins, tell us a little bit about Clark Doig.
Well, Clark and I became friends after he started working as a wrestler at KWA. He was an excellent technical wrestler, but he never really found a good gimmick while he was there.
Now, you said he never really had a good gimmick. Can you tell us what a gimmick is?
Yes, ma'am. A gimmick is the special thing that a wrestler does to be memorable or stand out.
So what was Clark's gimmick?
He was the dragon.
Describe this dragon for us a little bit.
It was meant to be comedic. It was a funny gimmick. He was supposed to wear a silly mask and a long cape.
At the night of the Brotherly Slam, what was Clark supposed to do as the dragon?
He was supposed to try a new aerial stunt where he would enter from the top of the ring.
Now, before we get into what exactly Clark was supposed to do, I want to ask, from your time working at KWA, have they ever done a stunt like this before?
Yes, ma'am, in 2021.
Were you there in 2021 when they did this stunt?
Yes, ma'am, I was.
Do you know a little bit about it?
Sure, so in 2021, the stunt was performed by Brett Bain, and we had a stunt coordinator there with us when we coordinated that stunt.
What exactly was wrestler Bane supposed to do during the stunt?
He was supposed to come down off the catwalk and then release himself about 5 or 10 feet above the ring.
Now, Mr. Gaskins, are you sure that in 2021 the wrestler was supposed to release himself?
No, it was actually the stunt coordinator and the owner, they worked on releasing in 2021.
So let's talk about the equipment that was used in 2021.
Okay.
What equipment was used?
There were the 2 locking carabiners, the vest, and a grappling rope.
Now, you mentioned 2 locking carabiners. Are you talking about this locking carabiner?
Yes, ma'am.
I'm now showing the witness what's already in evidence as Exhibit 8A. Who was it that decided to provide 2 of these locking carabiners?
That would be Miss Cody Cotter.
Are you sure it was Miss Cotter in 2021?
It was either Miss Cotter, or maybe it was the stunt coordinator who did the locking carabiners in 2021.
Does the stunt coordinator sound more correct, Mr. Gaskin?
Yes, ma'am, that sounds right.
In 2021, did anyone get hurt?
No, no one did.
From your experience at KWA, what was the difference between 2021 and Clark Doig's?
I'd say there were 2 main differences. In Clark's stunt, we didn't have a stunt coordinator. And then also it was the vest that was different. And it was uncomfortable for Clark in 2023.
In 2023, how was Mr. Doig attached to that vest?
He was attached with something called a snap shackle. It was different than the 2 locking carabiners.
Now, I want to turn back. I heard you say something about a stunt coordinator. From working at KWA, do you know why a stunt coordinator was not hired for Clark's stunt?
Miss Cotter said it would be too expensive.
Now, let's turn to the stunt that Clark had to do. Do you know equipment that was used for that stunt?
Yes, ma'am. There was the vest that Clark was wearing, which was connected to the snap shackle, and a green rope as well.
If I were to show you a diagram of all of this equipment put together, would you be able to recognize it?
Yes, ma'am.
Your Honor, permission to set up an enlargement of what's already in evidence as Exhibit 11. Granted. And would Your Honor like to see the enlargement as well?
Well, it's more important for the jury to be able to see it, so wherever you think it's appropriate for the jury, and if I need to come around and look at it.
Yes, Your Honor.
Your Honor, permission to reposition myself?
You may.
Oh, let me make sure you can see it, Mr. Gaskin. Looking at Exhibit 11, can you describe to us how this equipment was put together?
Sure. So there were those steel cables that would come down from the ceiling, and they would connect to the rack and the rope. And then attached to the rope was the locking carabiner, and the snap shackle was the last thing that was attached to the back of the vest that the wrestler would wear.
Now, you mentioned the snap shackle. Is this the snap shackle?
Yes, it is.
Let the record reflect the witness's identified Exhibit 6A.
The record will so reflect.
Now, Mr. Gaskins, would it help in your testimony of illustrating how this snap shackle was placed on Clark if you could get off the stand?
Sure.
Your Honor, may the witness step down.
You may.
All right, Mr. Gaskins. I want you to take this snap shackle and show us where it is here on Exhibit 11.
So on Exhibit 11, it's right here, connected to the vest.
Let the record reflect the witness has placed Exhibit 6A in the position on Exhibit 11A where it says snap shackle.
Well,
Now, Mr. Gaskins, I want us to pretend that I'm Clark Doig, and I want you to place that snap shackle on me where it would have been on Clark.
All right. So it would go on the back of the vest that the wrestler was wearing, and the rope would go around the shoulder, and it would be covered by Clark's cape.
Let the record reflect the witness has placed Exhibit 6A in the middle of my back with the green rope around my shoulder.
okay, it will.
How exactly was Clark supposed to be positioned during this stunt?
he was gonna have his arms out, and then right before he would get about 5 to 10 feet above the ring, he would then release himself by pulling that ring rope.
When you say his arms out, do you mean like this?
Yes, ma'am.
Let the record reflect that my arms are parallel to the ground. Okay. You can take your seat.
Thank you.
Mr. Gaskins, was the brotherly slam on August 6th the first time that Clark ever did this stunt?
No, ma'am, we practiced beforehand as well.
Were you at any of those practices?
Yes, ma'am, I was at the mall.
When did Clark practice?
He practiced the Tuesday before August 6th and on the morning of August 6th.
Let's start with the Tuesday before. What equipment did Clark practice with on the Tuesday before?
On the Tuesday before, he used his vest, the rope, and 2 locking carabiners.
Just to be clear, you're referring to this locking carabiner.
Yes, ma'am.
Did Clark have any problems using this piece of equipment?
Yes, ma'am.
Well, what were they?
He said that it was hard for him to release quick enough, and he was always adjusting himself.
Now, when you say adjusting yourself, to the best of your knowledge, what do you mean?
Clark told me that he was uncomfortable, that the vest would sometimes agitate his neck and his wrist, and he would be reaching for his cape sometimes.
Since we talked about the problems that Clark was having, let's talk about solutions. What was done about Clark being uncomfortable in that vest he was wearing?
Nothing, the vest never changed.
What was done about Clark releasing too slow from this locking carabiner?
Miss Carter changed one of the locking carabiners to a snapshot.
Well, let's talk about that snapshot, Cody. Did Clark ever practice with this snap shackle?
Yes, ma'am.
When were those practices?
On August 6th.
And just to be clear, what day was the brotherly slam?
August 6th.
Earlier, we talked about some problems that Clark had when he was practicing. So let's go through them again. What was done about Clark releasing too slow when he used the snap shackle?
When he was using the snap shackle, that's when they replaced the locking carabiner with the snap shackle because he could release quicker by pulling that green rope.
What was done about Clark being uncomfortable in that vest?
Nothing, we didn't change the vest at all.
And who brought in this snap shackle?
That would be Miss Carter.
And who provided the vest that Clark was wearing?
That would be Miss Carter as well.
Also, on August 6, 2022, were there any movements that Clark was doing that were ever addressed?
Yes, ma'am. There was one time where Clark was flapping his wings or flapping his arms almost like wings, and Miss Carter was sure to tell him not to do that because it could cause some issues.
Now, you said Miss Carter told him not to flap his wings. At any point when Clark was using this locking carabiner, did Miss Carter ever say anything about moving around?
No.
Now let's go to that brotherly stunt. When you saw Clark to begin to do his stunt, what did you see?
Well, because of where I was sitting, I could only see him for the last little bit of him falling, so I didn't see anything from up top. I only saw him falling to the ground.
Your Honor, at this time, a stipulation has become relevant. Permission to read it before the jury.
You may.
One moment, Your Honor, we have seemed to misplace the stipulation on our desk.
We thought it'd be if you would like.
Oh, I have it right here. Sorry about that, y'all.
Problem.
I'm now going to read you stipulation number 5, which means that the parties have agreed that Clark Doy's cause of death was blunt chest trauma, specifically a transected aorta and internal bleeding upon striking the rings mat on August 6, 2022. Thank you, Mr. Gaskins. Your Honor, I have no further questions.
Cross-examination.
Yes, Your Honor. Counsel, may I just grab the equipment real quick? Thank you. Good morning, Mr. Gaskin. Good morning. Now, I just want to clear something up that you mentioned on the rec. You said that the vest was different in 2021 than what it was in 2022.
I'm not sure if the vest was different from the 2021 event to the 2022 event. I just know that Clark didn't end up changing his vest from when he changed from the snap shackle to the canter gaiters.
Well, just to be clear for the members of the jury, all the equipment that was on that diagram that you walked through, that was provided in 2021,
Yes, it was.
including that vest.
I believe so.
And that was the vest that was used in this case.
I believe so.
And all that equipment was provided by stunt coordinators.
Yes, in 2021.
Now, Mr. Gaskins, let's talk about Clark Gold. He was AWA's most senior wrestler,
Yes, sir.
their most experienced wrestler.
Yes, sir.
And this wasn't his first time doing this stunt in the air, right?
Nope.
Right, he had jumped off 12-foot ladders.
Objection, Your Honor, relevance.
Your Honor, this goes to the reasonableness as to why KWA and Mr. Doig conducted the stunt in this case, as this goes directly to Mr. Doig's experience as a precision and technical wrestler.
Any argument, counsel?
Yes, Your Honor. The defense is attempting to use this to prove their assumption of the risk. Unfortunately, the defense must prove that Clark understood the risks associated only with the stunt on August 6, 2022. Clark has never done a stunt like this before. Therefore, they cannot use prior stunts that are not even close to the height of this stunt to be able to show that he assumed the risks. Therefore, it is not relevant.
Your Honor, may I briefly respond? We are not stating these prior stunts to meet our burden of assumption of the risk. As this witness has already testified to that Mr. Doig is an excellent technical wrestler, and these prior stunts go to why he is an excellent technical wrestler.
Overruled. You can re-ask the question and the witness can answer.
Yes, Your Honor. Mr. Gaskins, I'll repeat my question. He had jumped off 12-foot ladders,
Yes, sir.
as well as 16-foot cages.
Yes, he did.
As you mentioned on direct, Mr. Doig was an excellent technical wrestler.
Yes, sir. I believe so.
Right, he was able to control his body
Yes, sir.
and land safely.
Yes, sir.
Now, I want to talk about the stunt. Cody Cotter pitched the stunt to Mr. Doig,
Yes, sir. Ms. Cotter came up with it.
and Mr. Doig agreed.
Yes, sir.
In fact, you actually even heard Mr. Doig say that he thought that this stunt would get the dragon over.
Yes, sir.
You know the term over in the wrestling industry means successful, right?
Right.
Well, let's talk about the plan for this stunt. The plan was to have Mr. Doig go out with his arms to the sides,
Yes, sir.
keeping his arms still,
Yes, sir.
meaning he definitely wasn't supposed to flap his arms.
No, that's true.
Well, let's talk about how that plan was practiced. Cody Cotter and Mr. Doig practiced this stunt.
Yes, sir. There were 8 total times that the stunt was practiced.
Right, and they practiced on 2 separate days.
Yes, sir.
And they practiced together.
Yes, sir.
Let's start, you were there for both practice days, correct?
I was.
And as you mentioned on direct, you saw the equipment that was used on each day.
Yes, sir. I did.
Let's start with the first practice day. This was 4 days before the event,
Yes, sir.
and they practiced with this carabiner.
Yes, sir. We used the locking carabiners on the first practice.
Right, which means that Mr. Doig agreed to descend from the ceiling,
Yes, sir.
attached to this carabiner,
Yes, sir.
and then release himself.
Yes.
In fact, you heard Mr. Doig say that it just felt lame,
Yes, I did hear him say that.
dangling,
Yes.
trying to unlock this thing.
Yes, sir.
And just to be clear for the members of the jury, Mr. Doig complained about the extra 10 to 15 seconds it took to release.
Yes, he did.
Let's talk about the second practice day. This was the same day as the event.
Yes, sir. August 6th.
And Cody Cotter brought this shackle to the arena,
Yes, she did.
along with this rope.
Yep.
And Cody Cotter showed the shackle and rope to Mr. Doig.
Yes, she did.
And together, they practiced with the shackle.
Yes, sir. They practiced 4 times on August 6th.
And in those 4 practice runs, that means that Mr. Doig agreed to descend from the ceiling,
Yes, sir.
attach to this shackle,
Yep.
and to pull this rope to release himself.
Yes, sir. That was the plan.
And after those practice runs, you heard Mr. Doig say, it feels so, wow, it's so much easier to open this shackle than the other one.
Yes, sir.
And you mentioned that they practiced with this shackle 4 times, correct?
Yes, they did on August 6th.
Let's talk about those 4 practice runs. During those runs, Mr. Doig, he didn't stick to the plan.
What do you mean?
Mr. Gaskins, you saw Mr. Doig flap his arms.
He did, and that's when Miss Carter corrected him and told him not to move around too much.
Right. Specifically, you heard Cody Cotter say, don't do that thing with your arms.
Yes, sir.
You heard Cody Cotter say, it's not safe.
Yes, sir.
Now, those practice runs were just a few hours before the event, right?
Yes, sir.
And we'll get to those hours in between the stunt, in between those practice runs and the stunt in a moment. But I just want to make something very clear to the members of this jury. KWA had pitched Mr. Doig multiple character ideas.
Yes, sir.
And when that happened, Mr. Doig had turned those ideas down.
He had turned down a few different ones. The dragon was the first one to really land.
Right, meaning that KWA never pressured Mr. Doig into those previous ideas.
Not that I'm aware of, no.
Now let's get back to those hours in between those practice runs and the stunt. During those hours, you never heard Mr. Doig raise any concern about this stunt.
I remember he said that the vest was uncomfortable, but that's all I can remember.
You never heard him raise any reservation about this stunt.
Not that I know of. He was going to go ahead with the stunt.
And later that night, you actually went to go check on your very good friend.
I did.
You made sure he was ready.
Yes, sir.
And you actually asked Mr. Doig, are you sure you want to do this?
Yes, sir.
And in response, Mr. Doig laughed.
He did.
And after he laughed, he said, it's time for the dragon to fly.
Yes, sir. That was the plan.
Moment to confer, Your Honor.
You may.
No further questions, Your Honor.
Any redirects?
Yes, Your Honor. Mr. Gaskins, have you ever known Miss Cotter to be a stunt coordinator?
Objection, Your Honor. Leading.
Overruled, you can ask.
Have you ever known Miss Cotter to be a stunt coordinator?
No, ma'am.
Have you ever known Mr. Doig to be a stunt coordinator?
No, ma'am.
Now let's talk a little bit about those practices. How many times did Clark practice with the snap shackle?
That was only on August 6th, so it would have been 2 times because it was actually introduced after the second time.
How many times specifically did he practice with the snap shackle on August 6th?
That would have been 4 times.
Which one of those 4 times did Miss Cotter go down and say, do not move your arms like that?
Objection, Your Honor. Leading.
Overruled, you can answer if you know the answer.
It was on the second time we were running it.
So to the best of your knowledge, how many times did Clark practice with the correct instructions?
Twice that day.
And who decided to use the snap shackle?
Objection, Your Honor. Asked and answered.
If it has been, I don't recall the answer, so you can go ahead, overruled.
Who decided to use the snap shackle?
That was Miss Cody Cotter.
And who that day decided not to hire a stunt coordinator?
That was Miss Cotter as well.
Thank you, Mr. Gaskin. Your Honor, I have no further questions. I ask that the witness be allowed to step down.
Any recross?
No, Your Honor.
All right, you can step.
And at this time, Your Honor, I will also be publishing Exhibit 11 with the jury.
Plaintiff calls River Sukesh to the stand.
Morning, sir.
Morning, Your Honor.
You may be seated. You've already been sworn. Counsel your witness when you are ready.
Yes, Your Honor. Please introduce yourself.
My name is River Sukesh.
Mr. Sukesh, what do you do for a living?
I am the Chief Stunt Safety Officer at Walt Disney Studios.
What exactly is a chief stunt safety officer?
So as a Chief Stunt Safety Officer, I oversee all of the stunts that you see in like Disney movies and productions. So that includes the safety and the execution.
Did you go to school to become a chief stunt safety officer?
Well, that wasn't my major, but I did get a bachelor's degree in mechanical engineering.
And what did you do after school?
After school, I started working as a stunt reading assistant and worked my way up to where I am now as a Chief Stunt Safety Officer.
How long have you been in the field of stunt safety?
I believe at least 23 years.
Do you have experience in designing stunts?
I did.
Do you have experience in selecting equipment for stunts?
Yes, I did.
And outside of school, do you have additional certifications in your specific area?
Yes, I am a certified safety professional.
Mr. Sukesh, how many stunts have you overseen in your career?
Over the 23 years, probably about 100 stunts or so.
And out of those 100 stunts, how many involved falls or descents like the one in this case?
So out of the 100, probably about 25 involved descents or falls of greater than 40 feet.
Now that we've got to know you a little bit, let's talk about your involvement in this case. How did you become involved in today's case?
Well, I was retained by the state of Mr. Doig to analyze the circumstances surrounding the August 6th stunt and then come to an opinion on what happened.
Now, you said you were retained. Are you being paid for your time today?
I am, yes.
How much are you being paid for your time?
I was retained and I'm being paid $750 an hour.
Have you ever testified in a wrestling case before?
I haven't.
Does that affect your ability to form an opinion in this case?
No, it doesn't.
Why not?
Well, really stunts are stunts, no matter where they're performed. And they should be safe regardless.
Mr. Sukesh, without going into your opinion, did you form an opinion in this case?
Yes, I did.
What did you review in reaching this opinion?
So I reviewed all the materials that were exchanged as exhibits on the joint exhibit list between the two parties. And I also did a personal inspection of the catwalk, the arena, and the wrestling ring at KWA and the equipment that was used in the stunt.
Are the materials you review same types of materials that other experts in this field normally rely on?
That's right.
In forming your opinion, did you use reliable principles and methods?
Yes, that's right.
Did you reliably apply those principles and methods to the facts of this case?
I did.
Are your opinions based on sufficient facts and data?
Yes, they are.
And are your opinions to a reasonable degree of professional certainty?
Yes, they are.
Well, let's talk about your opinions now.
1 second, counsel. Is there any voir dire that the defense would like to ask the witness before we proceed?
We have no objection to this witness, Your Honor.
All right. Go ahead, counsel.
Yes, Your Honor. We're going to talk about your opinions now. What led to Clark's fall on August 6, 2022?
Well, based on everything that I reviewed, there are several things that I looked at, but the first thing is that the design of this stunt was just dangerous. And not only that, KWA did not have a backup plan in place for the stunt, and they did not use a stunt coordinator in the stunt.
Did you have any other opinions in this regarding this stunt?
Oh, yes, specifically the design of the stunt, the equipment that was used, the snap shackle that we've seen already was just unsafe.
Now, you mentioned several opinions, so we're going to take those one by one.
Sure.
I want to start with the stunt coordinator first. And first off, what is the stunt coordinator's role in stunt performance?
So it's exactly how it sounds. A stunt coordinator coordinates stunts. But specifically, they oversee the safety, the preparation, the planning, all the way up until the execution. And really the most important reason that the stunt coordinator is there is to recognize any flaws with anything that has to do with the stunt.
And knowing that, was a stunt coordinator hired on August 6, 2022?
No, KWA did not hire a stunt coordinator.
Had KWA hired a stunt coordinator in the past?
Yes, they did. They had hired a stunt coordinator just the year prior.
Is that 2021?
In 2021, yes.
And in 2021, what equipment was used for that stunt?
So the equipment in 2021 was almost the exact same equipment in this stunt, except there was no snap shackle.
So what was the difference in the 2021 stunt and the 2022 stunt regarding the equipment?
So in 2021, with the stunt coordinator, they used 2 locking carabiners. In 2022, they used the 1 carabiner and the snap shackle.
In 2021, when KWA used the stunt coordinator and the locking carabiners, did anyone get hurt?
No one was hurt or injured in 2021.
Now, you just mentioned the snap shackle, so let's talk about that snap shackle. What is a snap shackle?
So again, as we've seen today, it's a small piece or a small piece of metal equipment, and it's used to connect lines. It's not typically used for stunts.
Citing court and opposing counsel to what has already been admitted into evidence as Exhibit 6A. Mr. Sukesh, did a stunt coordinator approve the use of this snap shackle?
In 2022, with this stunt, no.
Who decided to use the snap shackle?
From what I understand, it was Cody Cotter.
Now, you said that your opinion is that the snap shackle was unsafe. Why is that?
Well, when I mentioned that it's used for lines, specifically it's used on for sailboats or for sailing. It's not designed or intended to use for rappelling a person down from the catwalk.
Now, Mr. Sukesh, you also mentioned a piece of equipment called a locking carabiner. What is a locking carabiner?
A locking carabiner is that metal clip that we've also seen, and it's actually used in stunts.
Citing court opposing counsel to what has already been admitted into evidence as Exhibit 8A. Mr. Sukesh, is a locking carabiner typically used for something like this?
Yes, it's the expectation as far as equipment goes for stunts that involve descents, like what happened in this case.
Do you understand how both pieces of equipment work?
Yes, I did.
Can you show us how both pieces of equipment work?
Yes, I can.
Your Honor, may the witness step down to better explain the equipment to the jury.
Okay.
All right, Mr. Sukesh, I'm now handing you Exhibit 6A, the snap shackle. How does the snap shackle open?
So this is the snap shackle, and this top piece, this top piece right here, you would hold it like this. There's a hook and then this pin. And the pin, once you pull it, it releases.
How much pressure did it take to pull that pin?
So the snap shackle only requires about 9 pounds of pressure to open it.
And how far does that pin need to move to open?
So as you see right here, it's a small pin. It's 1/4 of an inch. So it's 9 pounds of pressure to pull 1/4 of an inch of pin.
Take that from me now. Mr. Sukesh, I'm now handing you Exhibit 8A, the locking carabiner. How does the locking carabiner open?
So the locking carabiner obviously looks different. It's a clip, and it takes a couple more steps to open it. It's not just a pull. It's actually not a pull at all. It's a twist of the lock, and then it's a push.
How much pressure does it take to twist and then push the locking carabiner?
So that's the other main difference between the locking carabiner and the snap shackle, is that the twist of the locking carabiner requires 10 pounds of pressure, which is already more than what the snap shackle is. On top of that, once you push it in, that's 30 pounds of pressure. So 2 steps, more pressure.
Why is the difference in pressure between the two important?
Well, just as I showed with that and with the locking carabiner, this one's much more difficult to open. It doesn't, the likelihood of it accidentally opening is much lower on the snap shackle.
And I'll take that from you now. Mr. Sukesh, out of these two pieces of equipment, which is the most safe for this time?
The locking carabiner.
You may retake stand, Mr. Sukesh. Now, you just told us that the locking carabiner was the most safe this time, but is there a safe way to use the snap shackle?
Yes, kinda. If KWA was set on using the snap shackle as they were, like I mentioned, they should have had something called redundancy or a backup plan.
What would have been a safe backup plan for this stunt?
Well, at the very least, the bare minimum would have been to use 2 snap shackles.
Did KWA have 2 snap shackles?
Yes, from what I understand, the snap shackles come in packages of 2. And if they would have used the 2 that they had, they would have put both on Mr. Doyd's vest. And if one accidentally released, like what happened, he would still be connected by the second.
Now, we've talked about stunt coordinators and equipment, but I want to talk about your other opinion, the design. How was the August 6th stunt designed?
It was designed for Mr. Doig to quickly release. He would be rappelled down, and about 5 feet before he hit the mat, he was supposed to pull that green cord that we see attached. And then that he would pull it and release himself.
Was this design safe?
No, the design was not safe. And can't be much more clearer other than the snap shackle should have never been used for this stunt.
No further questions, Your Honor.
Yes, Your Honor. Can I proceed?
You may.
Mr. Sukesh, you were able to visit the KWA arena.
Yes, I inspected it.
You inspected all of the equipment.
Yes,
Those cables weren't broken.
they were.
That's the best we heard a lot about today. It wasn't.
None of the equipment was broken.
None of the equipment you saw that day was damaged in any way.
None of the equipment was broken.
Let's be clear. KWA owned all of that equipment other than the shackle from a prior stunt.
Yeah, yes, everything outside of the center.
From a prior stunt
Yes,
in 2021
yes,
when Mr. Doig was actually working for KWA.
yes,
In that 2021 stunt, they used that carabiner you were talking about.
yes,
The industry standard carabiner,
yes.
locking carabiner. You didn't use that in Mr. Doig's case,
They used one of them.
but they also use that shackle.
Right.
Let's talk about the difference between the two. Let's make this clear for the members of this jury. This stunt started with Mr. Doig using the industry standard carabiner.
Correct. It started off the right way. Yes,
He practiced with that carabiner.
they did.
You're aware that Mr. Doig complained.
Yes, about the about dangling in the air, I think. Yes.
He said it feels so lame,
Yes, I think he said that. That's right.
just dangling there, trying to unlock this thing.
Trying to twist open the carabiner. Yes.
Cody Cotter bought a shackle.
2.
She bought 2 shackles, and let's be clear, Mr. Sukesh, she didn't just slap it onto Mr. Doig's vest and say good luck.
I don't think she ever said good luck, but she did give it to him to use.
Well, before she gave it to him to use, she actually tested it
Yes.
4 times.
I'm sorry. Do you mean tested it before Mr. Doig?
Before Mr. Doig ever even arrived to the arena, Miss Carter was testing that shackle
Yes, with the sandbag.
with a sandbag that weighed 250 pounds.
Right.
Mr. Doig, he weighed 177 pounds.
That's right.
The weight wasn't an issue.
No, not with the strength of the snap shackle. Weight was never an issue.
There were 4 successful practices with that sandbag and that shackle before Mr. Doig ever got to the arena.
Yes, that's right.
Then Mr. Doig arrived, and Miss Carter actually offered to do something.
Okay. Yes.
She offered to put on a vest.
Yeah. Yes.
She offered to go up 78 feet,
Yes.
rappel down into the ring.
Yes.
She offered to release herself
Yes.
and show Mr. Doig how that shackle worked.
Yes.
Mr. Sukesh, that didn't happen.
I don't think it did. No.
Well, you've reviewed the entire record.
Yes.
You're aware it didn't happen.
Well, no, I'm a little confused what you're asking. Are you asking if Miss Cotter offered to put herself in it and release herself?
Exactly right. Miss
Okay.
Carter offered to do the stunt before Mr. Doig could ever do it himself.
That sounds right.
But that didn't happen.
think it did.
You know it didn't happen.
Yes, yes.
Mr. Doig wanted to practice himself.
Yeah.
But before he could ever put his hands on that shackle, he received a warning.
Yes,
He was told, keep his arms out straight
yes, sorry,
and not move.
yes,
That could pull the cord.
yes,
And you were in the courtroom earlier when Sid Gaskin testified.
yes,
You heard Mr. Gaskin say that Mr. Doig only ever practiced with 2 correct instructions, to not move.
right.
But you know that's not true.
Yes, tell me,
Well, I'm not going to tell you. You're aware that Mr. Doig was warned before he could ever practice this stuff, correct?
yes, so keep his arms out,
Keep his arms out and to be still.
yes,
Let's talk about his practices now. On that first practice run, Mr. Doig stuck to the plan.
yes.
Well, he didn't flap his arms.
Yeah.
The pin didn't release early. Then they practiced again for a second time, Mr. Sukesh.
They did.
Mr. Doig did something different.
Yes, yes,
Well, he flapped his arms.
yes,
And Miss Carter, she ran down to the ring.
sure, yes,
She yelled at him.
yes,
She said, don't do that thing with your arms.
yes,
She said, it's not safe. She told Mr. Doig, it's a matter of life and death.
yes, that's what she says she told me.
That was his second warning of the day.
After being told to stay still, yes,
And then they practiced again for a third.
yes,
And on that third practice where Mr. Doig stuck to the plan,
yes,
he didn't flap his arms.
right,
The pin didn't release early.
it did,
And then they practiced again for a fourth time.
yes,
And Mr. Doig stuck to the plan.
yes,
He didn't flap his arms.
yes,
The pin didn't release early.
it did,
Mr. Doig actually had something to say about the shackle after that fourth practice run.
yes,
He said, wow, the shackle is so much easier to open than the other one.
yes, Mr. Doyle said that,
Mr. Sukesh, any inadvertent movement could cause that shackle to open.
it could,
And that shackle was taped to Mr. Doig's shoulder.
yes, it was,
He knew it was there.
Yeah.
Let's talk about the brotherly slam.
Sure.
Brotherly slam was later that evening. This is a big championship event.
yes,
But to be clear, Mr. Doig, he wasn't the headliner.
no, it wasn't,
He was in the middle of the show.
yes,
And Miss Carter would be in charge of the ropes.
right,
They would be doing the stunt together.
Yep.
And as Miss Carter was lowering Mr. Doig down, she saw something.
yes, that's what she says,
She saw 1 or 2 quick movements with his arms.
yes,
That's when she saw Mr. Doig fall.
yes.
Your Honor, a moment to confirm. You may. No further questions. All right, let me redirect.
Yes, Your Honor. Mr. Sukesh, opposing counsel talked a lot about warnings, but was Clark ever warned that the snap shackle was used for sailboats?
No, it was not.
Was Clark ever warned that the snap shackle came in a pack of 2?
Objection leading.
Overruled. You can answer.
No, only Mr. Cotter knew that it came into, or at the time, Mr. Doig did not know that it came into effect or came to.
Now, opposing counsel also talked about practicing with the snap shackle before Mr. Doig. What is the difference between a sandbag and Clark?
Well, there was a weight difference, but as we talked about, weight wasn't an issue here. The difference was the sandbag could move. It's not a person. Mr. Doig is a person.
Now, just to be clear, which piece of equipment was directly attached to Clark Doig's vest?
The snapshot.
And which piece of equipment opened early?
Objection leading.
Sustained.
Sorry, Mr. Sukesh, which piece of equipment opened?
The snapshot was the only piece that opened.
No further questions, Your Honor.
Any of your cross?
No, Your Honor.
Sir, you may step down. Any further witnesses or evidence on behalf of the plaintiff?
No further witnesses, Your Honor. The plaintiff rests.
Your Honor, at this time, the defense does have one motion to be heard outside the presence of the jury.
All right, the jury is constructively not here, so go ahead whenever you're ready.
Yes, Your Honor. At this time, the defense moves for a judgment as a matter of law pursuant to Federal Rule of Civil Procedure 50A. When viewing the evidence in the light most favorable to the non-moving party, the plaintiff has failed to put forth sufficient evidence from which a reasonable jury could find that they have met their burden. And looking at all of the evidence and the testimony today, everything supports that KWA and Clark Doig were in this together. That together they agreed to do the dragon character, together they agreed to do the stunt, together they agreed to use the shackle instead of the carabiner, and together they agreed that Clark Doig would do the stunt on the August 6th brotherly slaying. For these reasons, no reasonable jury could find that they have put forth sufficient evidence or meet their burden. So we ask Your Honor grant the motion.
Counsel.
Yes, Your Honor, this motion is due to be denied. Viewing the evidence in the light most favorable to the non-moving party, which in this case would be the plaintiff, we have provided sufficient evidence today that a reasonable juror could find that KWA was negligent. The fact that Clark did this stunt along with KWA does not mean that they cannot be negligent. We provided evidence today that it is Mrs. Cotter who owns KWA, it is Mrs. Cotter who brought in that snap shackle, and it is Mrs. Cotter who decided to use that snap shackle. Clark just works there. Further, we provided evidence today that they failed to provide a stunt coordinator, they failed to use proper equipment for that stunt, and that Clark did not know what that shackle was used for. For those reasons, any reasonable juror could find that those failures caused Clark Doig's death, and therefore this motion is due to be denied.
Any rebuttal, counsel?
Your Honor, all of the evidence in the testimony demonstrates that they were together in every single decision, not Mr. Doig assumed this risk. No reasonable jury could find the plaintiff has proven an act of negligence on KWA's behalf. We ask Your Honor deny or grant the motion.
All right, after considering the arguments of counsel in light of Rule 50 and the applicable case law, the motion is denied. Only the jury may weigh credibility, and the plaintiff certainly has met its burden of producing evidence as to each element of its negligence claim. That is the basis of the court's denial of the Rule 50 motion at this time without prejudice to renew at the end of the trial. All right, we'll take a break. 5 minutes sufficient for everyone?
Yes, Your Honor.
First, plaintiff has 23 minutes and 3 seconds, defense has 38 minutes, 27 seconds. Yes.
Thank you.
Should we not speak to the parties?
Probably not.
Oh, thank you.
Where'd you go?
Yes.
Oh, that's sick.
5 days.
I don't think that is fine. I don't.
Okay.
Thanks.
Dispute about it, there's nothing to do, it's cross. You just have to cross the choice. Can you in your cross, what's that in your cross?
That's in very, lock your beard and very.
I think we just do it.
So we can. I think you're not.
No, because I mean, it was within. When you still have 22 minutes, I mean, excuse me, 12 minutes to close, and it goes to her level. Say 22. She said 22, so I'm gonna go off 22. I think we can forget it, I'm sure it's strong.
One of those, yeah, right near the white ones. One of those circumferential, like, buildings or the house. They built all those apartments, I think they're condos.
One of them is a condo, one of them is a condo building, my parents are in that one, 575. Thanks.
Here's somebody.
The plaintiff is ready to proceed once everyone's together.
And so you're likewise ready to proceed?
Yes, Your
Yes, Your
Honor.
Honor.
Is that okay, very good. And timekeeper, you're ready to proceed?
Yes, Your Honor.
Okay. With that defense, you can call your first witness.
Your Honor, at this time, the defense calls Cal Sism.
Good morning, ma'am. You can be seated. You've already been sworn. Counsel your witness whenever you're ready.
Good morning. Can you introduce yourself to the members of the jury?
Good morning, my name is Cal Sism.
Ms. Sism, how are you involved in today's case?
I was hired by the defense to analyze and come to an opinion regarding the safety equipment used in the stunt surrounding Clark Joy's death.
Well, before we get to that opinion, let's give the members of the jury the opportunity to get to know you. What do you do for a living?
I'm the owner and the founding principal of Safe Performance Solutions.
What kind of work is safe performance?
Well, we provide safety solutions and advice to those involved in the dangerous sport of wrestling and stunt entertainment.
Well, what kind of schooling did you get to get into that line of work?
Well, I have a bachelor's degree as well as a master's in occupational safety and health.
Ms. Sism, after you graduated with those degrees, what did you do for a living?
I started off in the stunt industry first, so I was a senior stunt coordinator for Warner Brothers Studios actually, before I decided to transition into the wrestling industry.
Well, tell us about the transition into wrestling.
I started working for the WWE at first, the World Wrestling Entertainment. It's basically the Premier League of wrestling. It's what you think of when you think of those big televised events.
What actual work were you doing for the WWE?
I was a senior stunt coordinator as well as a safety consultant. So basically, I was the girl that you would come to if you wanted to do something risky, but make it safe.
How long did you do that for?
I worked with them for about 8 years before I decided to move and do independent work.
Ms. Sism, do you hold any special licenses or certifications?
Yes, I do.
What?
I am a certified safety professional.
And are you a member of any professional groups or organizations?
I am, yes. I am a member and former senior vice president of the American Society of Safety Professionals, and I'm also a member of the Wrestling Professionals Association.
Have you ever consulted in your work before?
I have, yes.
How many times?
Over 60 times.
Have you ever testified as an expert witness before today?
I have.
How many times?
4 times prior to today.
Generally, when you're testifying, who is it that you're testifying on behalf of?
And generally, it's on behalf of wrestling industry or wrestling companies.
Are you being paid for the work that you're doing today?
Yes, I am. To date, I've made $31,000 for my work and my research and coming to my opinion. And then I'm also paid an additional $1,000 for my time testifying at trial.
Well, let's talk about that time before trial. Were you able to review any documents, any materials before coming in today?
Yes, I did.
What did you review?
I reviewed all of the exhibits that are contained in the record, as well as Mr. Sukesh's expert report. And I also conducted an independent site inspection of the arena and all the equipment that was used in the stunt.
Ms. Sism, were you able to learn about Mr. Doig's background as a wrestler in that review of the record?
Yes, I was.
Are those the kinds of things that experts in your field would rely on when they come to an opinion?
Yes, they are.
In your field, are there any certain policies or standards that you're required to hold yourself to?
Absolutely, yes.
Well, did you apply those in this case?
I did, yes.
Do you hold your opinions within a reasonable degree of professional certainty?
Yes, absolutely.
And Ms. Sism, let's just cut to the chase. How did you start your work in this case?
I started by going to the KWA arena with the plaintiff's expert, Mr. Sukesh, to inspect and review all of the equipment that was used in Mr. Doig's stunt.
Well, tell the members of the jury what the results of that inspection were.
Both the plaintiff's expert and I agreed that none of the equipment we inspected was broken or damaged in any way. It was only that the shackle had disconnected from the vest.
We've heard all day about the shackle. What was it designed for?
The shackle was designed for sailing.
Was that the safest piece of equipment that KWA could have used?
It was not the safest, but it was the most practical for this stunt.
Well, what do you mean by that? The most practical?
Well, this shackle allowed for a quicker release, which, based on my review of the record, is what KWA and Mr. Doig wanted for this stunt.
You mentioned practical, you mentioned safest, but was it reasonable for use in this stunt?
Given all of the circumstances, the use of this shackle was reasonable.
What do you mean by given all of the circumstances?
Well, Mr. Doig, the wrestler who was attached to that shackle, was an experienced and veteran wrestler. He had extensive experience in stunts that required expert precision and knew how to keep himself safe better than anyone else.
I want to focus on something you said just now. You said he had extensive experience in performing stunts. Tell the members of the jury what you mean by that.
Based on my review of the record, Mr. Doig had jumped from 20-foot steel cages down to the ground or from 12-foot ladders down to the ground, all without a harness, and was able to land safely without hurting himself or anyone else.
You mentioned 12 feet, 20 feet, but some was even higher. Does that change your opinion?
It does not, no, because for Mr. Doig's stunt, he was wearing a harness vest, which he had not done in those prior stunts.
Let's talk about the plan and the practice of this stunt. Can you tell the members of the jury about that?
Yes, so the plan was for Mr. Doig to descend in the stunt with his arms out to the side and keeping them still. He was warned by Miss Cotter, not to move his arms because it could cause the shackle to release early.
Do you know if he stuck to the plan when they practiced with the shackle?
On the first practice, yes, Mr. Doig was able to keep his arms still and not move. But on the second practice, I did note that Mr. Doig was warned after seeing him flap his arms, again, not to do that because it could inadvertently cause the shackle to open.
You mentioned the first two practices. Do you know if Mr. Doig stuck to the plan in the next two practices with the shackle?
Yes, so after Mr. Doig was warned for the second time not to move his arms in any way, he stuck to the plan, the subsequent practices, and kept his arms still, not moving them.
Ms. Sism, what's your ultimate opinion in this case?
It's my ultimate opinion that the use of the shackle within this stunt was not unreasonable, given that Mr. Doig was a veteran, experienced, and technical wrestler. He would be the one to release himself from that shackle and was in a better position to do so than anyone else.
Your Honor, a moment to confer.
You may.
No further questions.
Cross-examination?
Yes, Your Honor. Ms. Sism, your opinion is that the August 6th stunt was safe.
Yes, that it was reasonable and practical.
Right. And you say that knowing that this stunt was the cause of Clark Doig's life.
Yes, as long as Mr. Doig was to keep his arm still, the stunt would have been safe.
Let's talk about your opinions. Now, you would agree with me that even dangerous stunts need to be designed safely.
Yes,
And that's what stunt coordinators do, right?
yes,
They design the stunts
they do.
and make sure they're safe.
That's right.
And on August 6th, KWA did not use a stunt coordinator,
No, they did not.
but KWA has used a stunt coordinator before
Yes, when they did a similar stunt to this one.
in 2021,
That's right.
and they designed that stunt with 2 locking carabiners.
Yes,
In 2021, no one got hurt.
no,
2021, no one died.
no.
Now, Ms. Sism, you'd also agree with me that safe stunts are designed with safe equipment.
Yes,
Initially, the August 6th stunt was designed with the locking carabiners,
that's correct.
but KWA decided to use the snap shackle.
Yes, after Mr. Doig and KWA agreed that it was taking too long for him to release himself.
Right, they needed a quick release.
That's right.
So they switched out the locking carabiner for the snap shackle, even though the snap shackle, like you told us, is safer.
Yes, that doesn't mean that the shackle was unsafe, but yes, the carabiner was safer.
Right, and the carabiner is stronger
It could hold more weight, yes.
and it's harder to open.
Yes,
And the lock and carabiner is actually the industry standard for stunts like this one.
That's correct.
Well, let's see if we can figure out why the lock and carabiner is a safer option. So to open this lock and carabiner, all you have to do is twist it and
Yes,
push it in.
that's right.
Twist with 10 pounds of pressure
That's right.
and push in with 30 pounds of pressure.
Yes.
Well, let's see how something releases from this lock and carabiner. Miss Sism, I'm gonna attach this bag to the lock and carabiner. And whenever I release that lock, nothing falls, right?
No.
Whoever's attached will need to maneuver themselves around to release themselves?
Yes, that's why Clark Doig was struggling to release himself.
Right, so there really is no way to accidentally release from the lock and carabiner.
No, generally not.
We're gonna talk about snap shackle now. Like you told us, you know what the snap shackles are normally used for.
Yes,
They're used for sailboats, right?
that's right.
In fact, the manufacturer specifically makes them for sailboats.
That's right.
Manufacturer doesn't make them for wrestling stunts
No, they're used for sailboats.
or any kind of stunt,
No, they're normally used for sailboats.
right? And you can looking at this snap shackle, you can see it has a hook
Yes,
and a small pin.
that's correct.
In order for that pin to move, it only has to move a quarter of an inch.
Yes, it has to be pulled a quarter of an inch.
Right, pulled with 9 pounds of pressure.
Yes,
So the snap shackle releases quickly
yes,
and instantly.
yes.
Let's see something release from the snap shackle now. This is I'm attaching the same bag to the snap shackle. If this pin moves a quarter of an inch, this bag would fall. Is that correct?
Yes,
So you're telling us that Clark would have to stay nearly perfectly still while being dangled 70 feet in the air,
that's what he,
excuse me,
Sorry.
or the snap shackle would release
yes, that's what he was told before using the snap shackle.
and he would fall 78 feet.
Yes, that's why he was told not to move his arms.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Ms. Sism. Opposing counsel just got up here and tested the shackle for you. Why'd that shackle release?
It released because the rope and the pin were pulled.
Ms. Sism, why was it reasonable for KWA to have Mr. Doig perform this stunt?
Because given Mr. Doig's experience as a wrestler, he was able to do a stunt like this, given that he was given instructions and warnings on how to perform this stunt safely. He was told that if he moved his arms, that shackle could release, which unfortunately is what happened.
No further questions. May this witness be excused?
Any recalls?
No, Your Honor.
All right, maybe we step down.
Yes, Your Honor. At this time, the defense calls Cody Cotter to the witness stand.
Please come up to the witness stand. And be seated.
Counsel, may I grab you?
Go ahead.
Thank you.
Absolutely.
Your witness.
Yes, Your Honor. Good morning, Ms. Cotter. Can you please turn and introduce yourself to the members of the jury?
Good morning, my name is Cody Cotter.
Ms. Cotter, what's your connection to this case?
I own KWA and we hired Clark Doig.
What was your involvement on August 6th of 2022?
I oversaw the stunt on that day.
Now, before we get to August 6th, I want the members of the jury to get to know you a little bit better. How long have you been the owner of KWA?
I started KWA in 2018.
What made you want to get into wrestling?
Wrestling has always been in my family. My father owned a wrestling company as well, and when he passed, I decided to go ahead and do that as well.
Now, we've heard today about KWA from other people, but I want the members of the jury to hear it from you. So tell us, what is KWA?
KWA is a wrestling company. We're not as big as the WWE, but we are really proud of what we do.
And now, I want to talk about the stunt that we've heard about here today. Let's walk through the progression, starting at the beginning. Whose idea was it for the stunt?
The stunt was my idea.
Did Mr. Doig agree with this idea?
Yes, he did.
And now, before we continue to this stunt here, let's just take a step back real quick, talk about Clark Doig. When did KWA first hire Mr. Doig?
We hired him in 2019 and then re-signed him in 2021.
We've heard today about the dragon character. What was Mr. Doig's character before the dragon?
He didn't really have one. He was kind of trying to figure out what his gimmick would be.
You just mentioned a gimmick. Can you tell us what that is?
Sure. A gimmick is essentially a persona that the wrestlers take on, kind of to engage with the audience.
And had KWA ever pitched Mr. Doig characters or gimmicks?
Yes, we pitched a few different storylines to Clark.
And how did Mr. Doig react to those ideas?
He turned those down.
Now, let's get back to the stunt here today. Let's talk about the plan. We've heard today that a stunt coordinator wasn't hired for this stunt. But tell us, in your own words, why didn't you hire one?
We didn't hire a stunt coordinator for this stunt because we had done a similar stunt in the past. We had all the equipment and I knew how to do it.
And was it part of the plan to have Mr. Doig flap his arms?
Absolutely not.
Miss Carter, let's talk about practice now. Why'd you swap out the carabiner for the shackle?
Well, we had practiced with the carabiner about 4 times and Clark was having trouble getting out of it.
So how did you alleviate that concern about Mr. Doig struggling?
I looked up a shackle that could help with an easier release.
You just mentioned you looked up a way for a quick release. Where exactly was that?
I found a shackle on Amazon.
Would you recognize that Amazon ad if I were to show it to you here today?
I would.
Showing opposing counsel what has been pre-marked for identification as Exhibit 7. Your Honor, permission to approach the witness with the same?
You may.
And would Your Honor like a courtesy copy?
Sure. There's one. Thank you.
Ms. Carter, I've just handed you has been pre-marked for identification as Exhibit 7. You recognize this?
Yes, this is the shackle that I purchased on Amazon.
Is it in the same or substantially same condition as when you last saw it?
It appears to be, yes.
Your Honor, at this time, the defense offers Exhibit 7 into evidence.
Any objection?
Yes, Your Honor, hearsay.
Response?
Your Honor, this is not hearsay. This is an advertisement that is offered for this witness's notice and knowledge and goes to the effect that this witness had as to why they purchased this piece of equipment.
Any rebuttal argument?
Yes, Your Honor, this is hearsay because we anticipate that the defense will use all of these statements for their truth. They will use it to show that, in fact, they bought this snap shackle because it is made for a quick release, which is what this witness used it for. And they will be trying to use it to prove it for that purpose. Therefore, it is hearsay.
The objection is overruled. The exhibit may be admitted. The court will issue a cautionary instruction at the conclusion of trial so that the jury does not consider any of the statements within Exhibit 7 for the truth of the matter asserted, but only to show notice to the defendant. Go ahead.
Excuse me, Your Honor. And with that, can we get clarification that if opposing counsel should argue in closing statements any facts for the truth of this statement out of this, that we may object to that?
You certainly may, and I'll consider your objection at the appropriate time.
Thank you, Your Honor.
Go ahead.
Your Honor, permission to publish to the members of the jury by way of handout,
You may.
and also permission to retrieve opposing counsel's exhibits.
You may.
Thank you. There you go. Yeah. Perfect.
Thank you.
Sorry, sir. Ms. Carter, directing your attention to that advertisement ad, it says the phrase sailing hardware. Did that concern you at all?
No, this didn't concern me.
Why did it not concern you?
Because I was looking for a shackle that could hold a heavy weight and this one could. It could hold up to 880 pounds.
For the record, publishing has already been admitted into evidence as Exhibit 6A. Ms. Carter, is this the shackle you bought?
Yes, it is.
And directing your attention to that advertisement there, I don't see anything specifically about this green rope. Can you tell us what this is?
Sure. So, here on this Amazon ad, it talks about a lanyard cord or rope being able to be attached to the shackle. I found that rope in my home to attach it for the purposes of the stunt.
And you just mentioned that you attached the rope for the stunt. Where exactly was this rope attached?
It was taped to Clark Doig's back.
Now, when you first got the shackle and the rope, how did you go about testing them?
So at first, I attached a 250-pound sandbag, and I tested that about 4 times to make sure that it would be safe.
And when Mr. Doig arrived to the arena on August 6th, were you able to show him the shackle and this rope?
Yes, I did show it to him.
What, if anything, did you offer to do with the shackle and rope?
I offered to attach myself in the vest and do the stunt prior to him practicing.
How did Mr. Doig respond to that offer?
He said it wasn't necessary and just wanted to go ahead and try the stunt himself.
Now, before we get to those practice runs, what, if any, instructions were given to Mr. Doig about this shackle and rope?
I told Clark that he should not move because it would trigger the rope to open the shackle.
Now let's move to those practice runs. We heard today that there were 4 practice runs conducted. In those 4 practice runs, what, if any, additional instruction was given to Mr. Doig about this shackle and this rope?
I told him not to move his arms and to be still.
What exactly led to that instruction?
Well, during one of the practices that we did, Clark was moving his arms in a flapping motion, and I immediately went down there and I actually had to yell at him because I had to tell him it was a matter of life or death. It was all about his safety, and doing that would put him in danger.
Now, we heard today that there were only 4 practice runs conducted with the shackle and rope. Can you tell us why that was the case?
Yes, I offered to practice a few more times with Clark, but he said he was hungry and wanted to get something to eat before the show.
Now let's move to later that night during the show. As you lowered Mr. Doig down, what, if anything, did you see?
I saw him begin to do 1 or 2 motions with his arms.
Moment to confer, Your Honor.
May.
Your Honor, no further questions, just permission to approach the witness as well as the jury to retrieve the exhibits.
Unless they're going to be used on cross.
Yes, Your Honor, I will be.
Okay, so why don't we hold off until they've been used?
Yes, Your Honor.
Whenever you're ready, Counsel.
Ms. Potter, you started the Klein Wrestling Alliance in 2018.
Yes, I did.
Now, the first couple of years, you barely broke even.
Yes, that's true.
Then COVID hit and all live events stopped.
Yes.
So for over a year, you basically generated no revenue.
Yes, it was a really hard time for us.
You said yourself you had to start making money fast.
Yes, we did.
Then Clark became the dragon.
Yes, he did.
And you said at this point, you were willing to do anything to make money with Clark.
I was. He was a very skilled wrestler and I wanted him to be successful.
And that's when the Brotherly Slam was coming up.
Yes, that was our monthly live premium show.
Right, it's your monthly show.
Yes,
Premium event,
yes,
biggest money.
yes, that is correct.
So you pitched Clark a stunt.
Yes, I did.
And you've done a stunt like this before.
Yes, we did a similar stunt in 2021.
Well, let's talk about all the differences between 2021 and what you had Clark doing. In 2021, you hired a stunt coordinator.
Yes, we did. Her name was Sarah Williams.
2022, you did not call Miss Williams back.
No.
Now you said on direct it's because she taught you how to use the ropes, right?
Yes, she did.
It's also because you had to pay $2,000.
Yes, the cost was part of it as well.
Said you didn't see the point in paying.
Not when we had all the equipment and I knew how to do the stunt.
Right, because in 2021, Miss Williams provided you with the equipment.
Yes, she did.
And the original stunt was made with 2 of these snapshots.
Yes.
You did not use 2 of these snapshots.
In the 2022 stunt, no.
Because the snapshot was tricky, right?
Yes, it was very difficult for Clark to get out of it.
Right, he just dangled there for like 15 seconds.
Yes, that's true.
You said it looked terrible.
It did, yes.
So that's when you decide you need to get a new lock.
Yes,
So that's when you decided to get on Google.
yes.
Before you got on Google, you did not call Miss Williams back.
No, I didn't call her.
Then you found yourself on Amazon,
Yes.
where you purchased a snap shackle.
Yes, I purchased the shackle from Amazon.
And that snap shackle was only $15.99.
Yes, it is.
And Amazon told you that snap shackle is for harsh marine environments.
Yes.
And you got 2 of them when you ordered it off Amazon, didn't you?
Yes, it came in a 2-pack.
But you chose to only use one.
Yes, we only used one for this time.
Now you said ordering something off Amazon did not concern you at all.
The fact that it said sailing hardware didn't concern me, no.
Just so we're all clear, Miss Cotter, you're not a stunt coordinator.
No, I'm not.
Just so we're all clear, Clark Doyle was not a stunt coordinator.
No, he wasn't.
Let's keep talking about that 2021 stunt. In 2021, Sarah Williams practiced with the wrestler.
Yes, she did.
2022, you practiced with Clark.
Yes.
Now, while Clark was practicing with this locking carabiner, you saw that he was moving that vest around, right?
Yes, he was.
He was touching his gate,
Yes, he was.
touching his neck.
Yes, that's correct.
At no point, when Clark was using this locking carabiner, did you ever tell him not to move in that vest?
Not when he was using the carabiner, no.
Right. It was only when Clark was using this snap shackle, you told him not to move.
Yes, that's right. I told him it was a matter of life and death.
That's right, you told him this is a matter of life and death. Right?
Yes, that's true.
You said this is for your safety.
Yes, it was for his safety.
Because you knew if Clark fell out of this, he would fall.
Yes.
He could die.
Yes, and that's why I warned him not to do it.
So, Mrs. Carter, you gave Clark this snap shackle knowing it could kill him?
I gave it to him knowing that if he did a motion to trigger the shackle opening, that he could fall and it could be very dangerous.
Right, and if he fell, he would die.
That was a possibility, yes.
Let's talk about those movements real quick. You said during practice that you saw Clark flap his arms.
Yes.
And then up there on the catwalk, it was just you, right?
Yes, it was just me.
And you said you saw just 1 or 2 quick movements.
Yes, that's true.
And to be clear, when Clark flapped his arms during practice, he didn't fall.
No, he didn't.
Last thing I want to talk about is what happened in 2021 compared to what happened this time. In 2021, when Miss Williams conducted this stunt, the wrestler made it to the bottom safe.
Yes, he did.
In 2022, when you conducted this stunt, Clark would have died.
Yes, unfortunately, that's what happened.
I had nothing to do with it.
Were you right?
Yes, Your Honor. Potter, we just heard a lot about instructions and movements with the cape and vest. In the practice runs with the carabiner, what if any movements had Mr. Doig done with the
He didn't flop them, I don't believe.
Now, we also heard a lot about your actions on cross-examination, but I want to be clear for the members of this jury. Who agreed to the plan of this stunt?
Clark agreed to the plan.
And who agreed to practice this stunt?
Clark did.
No further questions, Your Honor. May this witness return to counsel table?
Unless there's any recross,
Your Honor, I have no recross.
then yes, you may step in.
And Your Honor, permission to retrieve the exhibits?
You may.
Yeah. Thank you. Thank you. Oh,
Need a brief break before closing or are you ready to close?
Yes, Your Honor, a break would be nice.
We'll take 3 minutes and then we'll reassemble for closing argument.
Your Honor, we do have a motion. Would
Oh,
you
I'm
prefer
sorry,
to hear that before closing statements after the break?
Are you ready now or would you like to have your break first?
We're ready now.
Okay, go ahead with your motion.
Your Honor, at this time, the defense renews its motion for a judgment as a matter of law. Even still viewing the evidence in the light most favorable to the plaintiff, they have failed to put forth sufficient evidence for which a reasonable jury can find that they have met their burden. In addition to our arguments raised at mid-trial, we have now heard expert testimony from Ms. Sism that says that it was reasonable for KWA and Mr. Doig to use the shackle in this case, given Mr. Doig's experience as a precision and technical wrestler. Therefore, we ask the court to grant our motion.
Counsel.
Yes, Your Honor. Viewing the evidence in the light most favorable to the plaintiff, they have not met their burden today, and this case must go to trial. The reason why is there are disputes that only the jury can decide. The plaintiff has brought evidence today that Clark Doig was uncomfortable in the vest, and it was unreasonable for them not to change that vest. That's why he could have fallen. That's a question only the jury can decide between the disputes of the two parties. Further, the defense has failed to provide any evidence that Clark Doig knew anything about this snap shackle, what it was used for, how dangerous it could actually be. They've only provided evidence that he agreed to it. That's not enough to meet their burden. Therefore, this motion is due to be denied.
Any further argument, counsel, before I decide the motion?
Your Honor, we rest on a prior argument.
The court has considered arguments of counsel and again declines to invade the province of the jury. Only the jury can weigh evidence and assess credibility of the witnesses. The Rule 50 motion is therefore denied, and you can all have your break, and we'll come back with the closing arguments.
Thank you.
Can you get attention?
Yes.
Time.
Plaintiff has 12 minutes and 30 seconds, defense has 22 minutes and 36 seconds.
Right, Your Honor, you have a rule that it's only 5 minutes for closing, isn't that right?
2.
Yeah, thank you.
I'm actually a magisterial district
I know.
judge, so in my court, it actually is 2 minutes.
I know, Your Honor.
And my jurisdictional limit is $12,000, but I'm small claims here today.
Which can be really interesting.
I love small claims cases. Yeah.
We also handle all the pre-hearings.
Yes, yeah, those are different.
I actually contacted, I've never been before, Your Honor, but he was a DA of 5 years. Said he didn't overlap, John McCall.
Okay.
I don't know if you know the name, but
So I left in 2014, and then I was elected in 21, starting in 22 as a judge, so there was like 7 years where.
you were in private practice?
Yeah, and still I am, yeah.
Oh, that's right, yes.
What do you handle in your private practice? And we're gonna do with the aerospace litigation and product liability, so that's why I volunteered. All the expert cases, because literally all I do is work.
Yeah. Oh, that's it.
Interesting.
Products
Is it a spam?
in terms of injury or?
Yeah, wrongful death, basically. Yeah.
I've done it before, but I just not check with bailiff individually and I'll ask Stetson as well.
I think I need to really just talk to you.
Did you?
Just to tell you that.
Okay.
2.5 years.
Do you know John?
Completely up to them.
Yeah.
What
years were you there at Chesapeake?
I left there in July of last year.
I know, it's about that time. It's not a price.
Big case.
Fun cases to be.
Oh, I know.
Yeah, I do,
I always done the, I think I
Kind of
ordered this
split
one
the three
online.
jobs doing huge straw purchases and like long-term grand jury investigations into campgrounds. Just thinking.
A little, yeah.
Your unit has the best presentation of any unit to the incoming people. It's the most entertaining.
Yeah. It's Bill and.
Blank out the name, tall guy.
Bill, yeah, that's the head of the unit. Yeah, he's good. We're in a different building, so I stay separate from all the chaos in the main office.
Great.
Oh.
So you came on under last.
Yeah, I,
Definitely not
I
that.
can like give you guys.
not so.
But perfectly thought works.
Yeah.
That's what I'm like saying,
July
that's okay,
last year.
I just wanna make sure that they don't want you to remain in the table.
I can say that.
Entire case.
Yeah.
But either way,
I face a little bit, yeah.
as long as they
more
get
serious stuff.
used for both sides.
Like in Chester County, I kind of, you're assigned to a courtroom and you kind of are a jack of all trades, master of none, you get a phone call about it.
That was my experience.
You know who we actually just signed it, actually. Well,
Brittany and I went here.
She was in my courtroom for a while.
she's a new associate with us.
Okay, wonderful. She was great. So I agree.
She is, yes, I'm chair of litigation.
Okay.
So, we're out for 60+ years, Monaco, we're 32 attorneys, but we just opened across the street from me.
So I'm only gonna use.
All my stuff's always been out here, but 6 months, just to take the offer, I will just hold it. To suburban station.
I was a big R5 writer for 7 years. Great Valley Flyer.
I certainly don't know.
Brittany was my
Yeah.
team leader.
Oh, good.
No, no claims, she's very.
Really,
Remember this year, I really want it.
That's my grandfather.
He was one of my CAs.
Oh, is that
He was
right?
really bright, yeah.
Oh,
Yeah.
Where is she? She'll be here.
that's gonna be a new show, everybody knows Brittany.
Well, tell her I said.
I will,
congratulations.
I will.
Okay.
You're on these. Nice, you're doing it. That's.
Oh, you're here. Okay.
Yes.
You ready, timekeeper?
Yes.
Council, whenever you're ready for closings, you may proceed.
Yes, Your Honor.
May it please the court. Close the council. $2,000 for a stunt coordinator who surely would have told this defendant to use that second snap shackle. That second snap shackle that this defendant already had. That second snap shackle that would have saved the life of Clark Doyle. Safety was never expensive. It was priceless. As the plaintiff, we had the burden of proving to you today that AWA was negligent. When they failed to provide sufficient safety equipment, when they failed to hire a stunt coordinator, and when they failed to warn Clark about the dangers of life. We have met our burden today. Because we showed you that safety was never expensive. It would have been priceless for the life of Clark Doyle. First, we showed you that they failed by using this snap shackle. So the 2 locking carabiners they already had. Now, I'll be the first to tell you, the law does not require that KWA use the safest option. The law does not require that they eliminate all risks. But if we learned anything today, it's that even Ms. Sism agrees that this is the least safe option that they had available to them. Well, how do we know that this is the least safe option? Oh, probably because it's used for sailboats. Even Ms. Sism agrees this is not used for stunts. You do not hang people in the air with this. You do not lower people down from this. This is attached to boats. And it's only worth $15.99. And they expected to lower Clark Doyle down from the ceiling in this. That's not reasonably safe at all. And you may be asking yourself, why in the world would this defendant go on Amazon and buy something worth $15.99 when they already have equipment available for doing a stunt just like this one? We know why. Just like a lot of other companies during COVID, this defendant was coming in on hard times. They were barely making money, they weren't turning a profit, and they needed something. Then the opportunity arose. The Brotherly Slam's coming up, Clark's the Dragon, fans are loving it, and they need that money. They need something, they need a stunt, they need an aerial stunt, because the Brotherly Slam is coming. KWA needs ticket sales, they need butts and seats, they need profits in their pocket. So what does this defendant do? They design a stunt to be dangerous. And how do we know it was dangerous? Because they had options. Sukesh told us today that they didn't have to just use this. Mr. Sukesh told us today that they could have used two of them. If KWA was so bent on using a snap shackle, they could have at least used two. They already had two, and one would have acted as a fail stop in case the other accidentally opened. They also already had two locking carabiners. Could have just used what worked. But they chose to use neither. It would not have cost them $1 more to use two snap shackles. It would not have cost them $1 more to use two locking carabiners. But by failing to use neither, it cost Clark Doig his life. That is unreasonable. We also proved to you today that KWA was negligent because they never called Sarah Williams back. Now, Ms. Cotter got up here on the stand today and she told you the reason she didn't hire that stunt coordinator is because she knows everything. She knows how to do the stunt, she knows how to run the ropes. Why would she hire that stunt coordinator? We know that's not true. We know that's not true because when Miss Williams did this stunt, Rester made it down to the ground. When Miss Cotter did this stunt, Clark Doig died. She did not learn anything. We know the real reason this defendant did not use that stunt coordinator is because this defendant did not want to spend $2,000. Safety was never expensive. Would have been priceless. The last thing we showed you today is that KWA failed and they failed to warn Clark about the dangers in front. Now, the defendant is making a big deal that Clark agreed to use this snapshot. He went along with it. It was the plan, and he never said no. Well, what did Clark not know about this snapshot? Never once today did you hear Miss Cotter say to Clark, hey, this is used for sailboats. Never once did you hear Miss Cotter say to Clark, hey, you know if you only move this 1/4 of an inch, you're gonna fall to your death. Never once did you hear Miss Cotter say to Clark, hey, don't move around in that vest you got. Because if you pull that green cord and you move in your vest, you know you might. Never once did you hear Miss Cotter say to Clark, hey, there's two of these available if you want to have a backup. That's what Clark Doig did not know. And you know what's so funny about the defense's argument is they try to say that they were in this together. Let's think about who owns KWA. That's Cody Cotter. Let's think about who planned this stunt. Cody Cotter came up with the dragon. Cody Cotter came up with the stunt. It was Cody Cotter said, hey, you're going to descend down and go back up. It was Cody Cotter who said, let's not use two locking carabiners. Let's just use the snap shackle. It was Cody Cotter who got on Amazon. It was Cody Cotter who placed the order. It was Cody Cotter who got the green cord out of her house of all places and strapped it to a device for sailboats. Clark did not plan a thing. It was Cody. And they also say they were in it together because they practiced. And I can guarantee you in just a minute, they're going to get up here and they say, it was Clark when he was flapping those wings during his practice. He was told, you can't move like that. And he did it during the show, and that's why he fell. That's why he fell, because he was flapping those wings. We know that's not right either. Because let's think about it. Clark is at practice. He flaps his wings. Nothing happens to that green cord. He does not fall out of it. But all of a sudden, he's at the show. And Miss Carter says he makes 1 or 2 quick movements. And then he plummets to the mat. He barely moves and he falls to the ground. That does not make any sense at all. But what does make sense is that Clark is there at the brotherly stand. And just like he's always done, he's fidgeting around with that vest. That same vest this defendant knew he was uncomfortable in. That same vest this defendant never changed. And what happens? Clark pulls that green cord and falls. Not because he's flapping. Doesn't even make sense. Now, in just a moment, Judge Smith is going to give you this verdict form. And it has some questions on it, so I want to go through it together. The first question is, did the plaintiff prove that the Klein Wrestling Alliance was negligent? Well, we know the answer to that is yes. We know it's yes because had KWA used that second locking carrier, had KWA used two snap shackles, had KWA hired that stunt coordinator, had KWA changed out that vest, then Clark Doig would still be here. Had any of those things happened, Clark Doig would be at home with his family.
Objection, Your Honor. May we approach?
You may.
Improper argument. This is a bifurcated case, as my opposing counsel mentioned. There has also been no testimony elicited today that Mr. Doig was a father.
Counsel, argument?
Yes, Your Honor. Mr. Gaskin said on the stand that he knew Clark as a friend and that he was a father and that he, knew him as a person, along with working at KWA.
All right, the objection is overruled, but I'll caution you, counsel, not to wade into the area of damages only, okay? All right.
But the defense doesn't want me to tell you that Clark would be here. That's why we know that safety was never expensive. Would have been priceless. That is why we ask that you find for the estate of Clark.
Ladies and gentlemen, you're not giving counsel for the defendant on Wrestling Alliance, whenever you're ready.
They were in it together. Members of the jury, at no point today have we ever denied to you this stunt was risky. It was a reasonable risk. It was risky. At no point today have we ever denied KWA wanted this stunt to be successful. But so did Clark Doig. Members of the jury, if there was anyone who could do the dragon stunt, it was Clark Doig. He was KWA's most experienced wrestler, their most senior wrestler, their most technical wrestler. That's why KWA pitched him this stunt. That's why he agreed to do it. Clark Doig agreed to do this stunt because he knew this was his opportunity to become Clark the Dragon Doig. They were in it together. Now, members of the jury, what happened to Mr. Doig is tragic. But the plaintiff doesn't get to stand up here, only point the finger at KWA and tell you this case is only about safety being priceless. Because, members of the jury, counsel's argument fails to recognize the part that Clark Doig had in the plan, in the preparation, and in the execution of this stunt. Because, just like my co-counsel, Mr. Yost, told you at the very start of this trial, this case is about KWA taking a reasonable risk. But it's also about Clark Doig assuming that risk. Because they were in it together. That's why this case comes down to two simple facts. They planned, they practiced. Together they planned the stunt. Together they practiced with the shower. And we're gonna talk about both of those things in just a second here, but we need to clear some things up. Because members of the jury, all day today, the plaintiff has told you the evidence would show Mr. Doig was pushed into this. He was forced into this. And this was an ultimatum. You know that's not true. You know how we know that's not true? Because plaintiff's very own witness, Sid Gaskins, took the oath, stood right here, and told you. Mr. Doig had turned down other ideas. He'd been pitched character ideas because he was a mid-card wrestler. He wasn't the headliner. But KWA certainly didn't fire him. They didn't punish him. They worked together to come up with new and exciting character ideas. Ideas Mr. Doig turned down. And when he turned those ideas down, what did KWA do? They didn't punish him, they didn't fire him, they didn't let him go, they didn't give him an ultimatum, no. They worked together to come up with a new idea. Members of the jury, we also need to address counsel's argument that this was some big money-making profit scheme. I told you, Brotherly Slam's coming, the Brotherly Slam's coming. Yes, members of the jury, it was also coming in September, because you know what, this was a monthly match. And Clark Doig, he wasn't the headliner. This was one stunt in the middle of one match. There was no guarantee for KWA that this would bring in a profit. There was no guarantee that this would put more butts in the seats, as counsel wants to say. But there was a guarantee for someone. There was a guarantee for Clark Doig. There was a guarantee that he could take his character to the next level. That's what brings us to the plan of the dragon descending down from 78 feet into the ring. Members of the jury, we agree. This stunt was risky. It was a reasonable risk, but it was risky. We are not disputing. But Clark Doig assumed that risk. And it makes sense. It makes sense that a technical, experienced wrestler would be willing to do a stunt like this. Makes sense that KWA would trust a wrestler like that to do a stunt like this. Because this wasn't KWA giving a rookie on their first day this stunt with that shackle, no. This was a wrestler with experience. Jumping off 12-foot ladders, 20-foot steel cages. He knew how to control his body. He knew how to perform stunts safely. And yes, in the past, KWA did use those two interlocking characters. And they did use a stunt coordinator. But members of the jury, let's have a moment of clarity here. Because all day today, the plaintiff has talked about how KWA was negligent for changing that shackle. But the plaintiff just stood up here and told you they wanted Cody Cotter to change the vest that was provided by the stunt coordinator they hired in 2021. They just can't have it both ways, members of the jury. And while we're talking about the equipment that stunt coordinator provided, let's talk about what Mr. Sukesh told you. He told you that is exactly how Clark Doig's stunt started. It started with using the industry standard equipment. But members of the jury, you know what Mr. Doig said. He said it feels so lame, just dangling there, trying to unlock that thing. He was embarrassed. His big stunt wasn't working the way he wanted it to. So what did Cody Cotter do? She bought a shackle. But she didn't just slap it onto his vest and say good luck. She tested it 4 times with a bag of sand before Mr. Doig could even arrive to the arena. And there were 4 successful practices with that shackle. And then Mr. Doig got to the arena. And you know what Cody Cotter did. You know she offered to put on the vest, to go up 78 feet, to rappel down into the ring and to release herself, to show Mr. Doig how that shackle worked. But that didn't happen. It didn't happen because Clark Doig said, it's okay. I got this one for myself. I'd rather test it out for myself. But before he could do that, he was told something. Members of the jury, let's make this crystal clear. Before Clark Doig could ever put a finger on that shackle, he was told, stay still. Don't move your arms. Could cause the rope to pull. Which brings us to the fact that they practiced with the shackle. All day today, plaintiff brought you this rope, showed you the shackle, even attached a bag to it to see exactly how it would release. The members of the jury, you know who saw this shackle. You know who saw this rope. You know who felt this release, not once, not twice, not 3 times, but 4 times. Clark Doig used this shackle. 4 times Clark Doig felt that exact release. 4 opportunities to say, whoa, I'm not doing that. That's way too dangerous. We need to use the carabiner instead. 4 times you know he did. Because members of the jury, you know exactly what Clark Doig said. He said, wow, this shackle is so much easier to open than the other one. And not only that, but you know what Cody Connor did when she saw Mr. Doig flap his arms on that second practice run? She ran down to the ring. Stop! Don't do that thing with your arms. It's not safe. It's a matter of life and death. And they practiced again, members of the jury, for a 3rd time. Mr. Doig stuck to the plan. He didn't flap his arms. The pin didn't release early. And then they practiced again for a 4th time. Mr. Doig stuck to the plan. He didn't flap his arms. The pin didn't release early. So when they were done practicing, it was reasonable for KWA to trust a veteran, experienced wrestler to stick to the plan, to follow the most basic of instructions, because they were in this together. And yes, you heard all of that from our witness, Cody Carter. Remember the jury, you don't just have to take Cody Carter's word, because you heard all of that from somebody else today. Sid Gaskins. Members of the jury, the plaintiff's very own witness, Sid Gaskins, confirmed all of this for you today. In fact, we were keeping count. 4 times today, Sid Gaskins took that stand and told you KWA and Clark Doig agreed to do the stunt. They agreed to the plan for the stunt together. They agreed to use the shackle instead of that carabiner. And they agreed to practice and perform the stunt at the August 6th Brotherly Slam. KWA and Clark Doig were in this together. In just a moment, Her Honor is going to instruct you on the law. And opposing counsel just brought up the verdict form. You know what it looks like. But it's really just asking you to look at a few simple questions. So let's talk about it. When you get to question 1, the judge is going to instruct you that the law means that KWA had to be reasonable given the professional wrestling industry. And members of the jury, as our expert told you today, and as you have heard all day, this was a reasonable risk. Reasonable given Clark Doig's experience in this field. Reasonable given his technical expertise. So you can mark that, no, the plaintiff didn't prove that. But even if you feel that KWA does have some responsibility here, your job here isn't done. Because that brings you to question 2, whether Clark Doig assumed the risk. Members of the jury, for every single reason we have just talked about, the answer to that question is yes, he did assume the risk. But there's just one more thing we need to address, because opposing counsel just got up here and she promised you that I would tell you Mr. Doig flapped his arms. Members of the jury, That's not what we're gonna do. Because you know today, Clark Doig did move his arms. But it doesn't matter if he was flapping, doesn't matter if he was fixing that vest, doesn't matter if he was just trying to keep still. Because Clark Doig assumed the risks associated with this stunt the moment he put on that vest. The moment he went up 70 feet in the air, the moment he agreed to use that quick release shackle. AWA took a reasonable risk. Clark Doig assumed that risk because they were in it together. Thank you.
Thank you, counsel. Any rebuttal arguments?
Yes, Your Honor. Opposing counsel told you they were in this together, and so that they were reasonable. This was a reasonable risk, because Clark knew what he was doing. Clark is an experienced wrestler. Y'all, Clark's not a stunt coordinator. Who is running KWA? Cody Cotter. That's who's in charge here. And don't let them confuse you by getting up here and saying, Clark knows what he's doing. Clark doesn't know a single thing about that snap shackle. He didn't know it was for sailboats. He did not know that there was 2 of them. He did not know that if he moved that pin a quarter of an inch, he would die. You cannot assume the risk for something you don't even know about. That's not how that works. And they want to say, oh, this is reasonable. Is it reasonable to let your wrestler who's not a stunt coordinator lead your business? Is it reasonable to not hire a stunt coordinator? Is it reasonable to go on Amazon to buy something to dangle someone 78 feet in the air? That's not reasonable. Now, the defense also want to say, oh, they can't have their cake and eat it too. Can't say the vest is broken, but the snap shackle wasn't. Well, the only thing that was a problem was that vest. And they knew that before that locking carabiner, before that snap shackle ever came into the picture. Clark was moving that vest when he was wearing locking carabiner. And if the defense would have gotten the money signs out of their eyes for wanting to make a quick, fast, and exciting stunt, they would see it wasn't the lock that was the problem, it was the vest. It's not what happened. Instead, this defendant chose that snap shackle. This defendant chose not to hire that stunt coordinator, and this defendant chose not to use 2 of those snap shackles. Safety was never expensive. It would have been pricey. Fine for the estate of Clark Doig.
We permitting Sir rebuttal? No, okay, all right. Members of the jury, you've now heard all of the evidence in this case and argument of counsel, and I've now instructed you on the law. Go ahead and deliberate.
Well,
Hey, good job.
Good job.
Yeah, absolutely, up to. Good job.
Fantastic.
Good job. Good job. Wonderful job.
Wonderful to see you all.
Hey, good job, wonderful job.
Hey.
Thank you.
thank you so much for giving me that.
Pleasure.
Appreciate it.
Thank you.
Great job.
Thank you.
Yeah, I think. I don't know what.
Do we need to leave that?
Oh, I guess we have to ask the bailiff. Do we have to leave?
We have to leave?
Oh, no, so
Okay.
the judges will submit their ballots, and then once I have the all clear, we can give comments.
Okay.
So I'll let you all know once I have that.
Great.
Is still a coffee out there?
There should be, hopefully.
There was the last time.
Sounds like they're cleaning stuff up in there.
Yeah,
That's why I got out of there.
Yeah, they're probably setting up